All right, so now we need to start a case number. You are the petitioner. You would fill out a form FL110110. Notice to respondent, so the other side's first name, last name right here, your first name, last name here. So in this box, it says that the other side, so the respondent, will have 30 calendar days to respond to the summons and the petition, FL100, that we're going to talk about below, and fill out FL120 and serve to the petitioner, so the one to you, and file it with the court, which will cost $435 as well. And then it says, please make sure you know what restraining orders are on page 2. When someone files for divorce, legal separation, then all restraining orders, meaning do not move any assets, separate community. You can only spend money on everyday things. It's called living expenses, attorney's fees, without giving a notice to the other side. But any extraordinary expense needs to be given notice 5 days before and get written consent from the other side or court order. And then fee waiver is, there are different forms to get fee waiver to not having to pay $435. There are FW001, FW003 that you can Google. All right, so number 1, Civic Center Courthouse, McAllister Street, 400 McAllister Street, San Francisco, California, 94102. This is the address you will get when you are in your county. For example, in San Mateo, it's 400 Center Street or something, but you got to Google it. So double check that it's Courthouse Family Court. The name and address and telephone number of the petitioner, petitioner's attorney, or petitioner without an attorney. So here I type Diana Romanovska, and this is my state bar number. So technically I would write S or just SBN, and then it would stand for state bar number. And then my law firm, address, phone number. And this is the page where it says standard restraining order, where you know what not to do. Removing children out of California, depositing, closing bank accounts and things like that, transferring, encumbering, concealing, basically not to do anything shady, because both of you will have fiduciary duty during the divorce to act in the best interest of finances for both of you, not just for one person. And right here it says you must notify each other at least 5 business days, not just days, business days prior to incurring these extraordinary expenses. It doesn't say written consent. So it has to say here, without here, transferring, encumbering, hypothecating, and concealing, or in any way disposing of any property, real, personal, whether community, quasi-community meaning outside of the state, anything outside of California, or separate without the written consent of the other party or an order of the court, except usual course of business or the necessities of life. So then it says you must notify each other. It could be construed that you have to notify about these things without consent, but only for that portion you have to get consent. I wouldn't risk it. So I would, for anything on these numbers, for example, I wouldn't move the child out of the state, was just notifying, hey, by the way, in 5 days I'm moving, because the consent piece is only here. It's just going to create a lot of problems. Although I have to say the form is a little confusing, because it seems like consent is only applicable for number 3. All right. However, you may use community property, quasi-community, or your own separate property to pay attorney to help you pay costs. Okay. All right, FL 100. So here, party without an attorney. So here you would type your name, firm name wouldn't apply, your address, city, phone number, email address, and then say attorney for, since you're going to be representing yourself, you would be saying self-represented. There are fancy words for that. I'm not going to suggest that you use them because you need to understand them yourself. So self-represented, state bar number here, California, 94. So, okay. Then you put the street address right here for the courthouse, petitioner. Don't forget to write the name of the petitioner first, last name, respondent first, last name. If you want to change your name, we'll come to that. So here you put your current name. Dissolution, we check off dissolution of marriage. So don't forget to check 1, 2. And then if you file it for the second time, let's say you forgot to type the date of separation correctly, then you file amended. You can only amend if you didn't serve the other side yet. Okay, you filed, you remembered, you didn't serve, you can amend. If you served, then you would need court's approval. Meaning you have to file a motion, a request for order, FL 300, get a hearing date, explain, and then the court will let you amend. Legal separation. We are married. So, or we're domestic partners, and our relationship was not established in California, which is fine. So 3 cases apply here. Then the residency requirement. You have to be at least 6 months in California or 3 months in the county. One of you. It doesn't have to be just you. You can check off, for example, you're allowed to check off respondent. If you are the one from another state, then respondent is here. You can check it off and it would qualify for divorce. If not, then you would file for legal separation. You would check off these boxes. And then once you meet the 6 months requirement, you can amend it to divorce without court's approval. Okay, second box. Our domestic partnership was established in California. Neither of us had to be resident or have a domicile in California to dissolve our partnership here. So if it applies to you, check off. And the third box, we're the same sex, we're married in California, but currently live in jurisdiction that doesn't recognize and will not dissolve our marriage. So this petition is filed in the county where we're married. Petitioner lives, the respondent lives. So it gives another option. Statistical facts. Now we have to define date of marriage, date of separation. So you type in date of marriage, date of separation, and don't forget the number 3, time from the date of marriage. So basically you need to do the math. How do we define date of separation? The date of separation is defined in code section 70. And this code section says that you have to have 2 things. Intent to separate, meaning you have to say that I want to be divorced, not just separate, but divorce. And second, you have to act accordingly. Even if you live together, you don't have to move out. You have to live like roommates, not like husband and wife. Don't wash his or her laundry. Don't cook meals together. Don't travel together. Don't have sex. Don't have don't file taxes together. Make a list of everything you would do like you were a roommate, and that would be the date of separation. And then you type years and months. So although it says years here, it means months. So years, months. 3B, registration date of domestic partnership. Same here. 3B3, time from date of registration of domestic partnership to date of separation. So fill it out here. Number 4, minor children. There are no minor children. But if you have minor children, you check off and then put name, birth date, and age. And then if you have minor children, then there is another form you need to fill out, which is FL 105. I'm not going to go into FL 105 here because it's a very self-explanatory form. Then we're going to number 5, legal grounds. You don't have to have cheating as a reason. California abolished fault state, which means legal grounds is divorce, irreconcilable differences. Make sure you check off A and then A1. If you want to annul the marriage, here are the 6 reasons for annulment. Nullity, voidable marriage or domestic partnership based on petitioner's age at the time of registration of domestic partnership. So if petitioner's age was minor, under 18, then that's a problem. Prior existing marriage or domestic partnership, meaning if you married and you didn't know that you weren't divorced, and then you found out after you got married, then your second marriage is void, meaning it can be nullified. Unsound mind, so you have to prove at the time when you married someone or you were not able to make decisions. Hard to prove. You cannot just say, well, we're drunk. It has to be really, we didn't know what we were doing. Fraud. This is the most common reason for divorce. For example, if the marriage was never consummated, meaning you never had intercourse after you got married, or someone was using you for green card. This is a tough one. I had a trial about this for 6 days. It's not easy to prove. Mostly reasons that are very compelling, that someone didn't disclose a very significant fact. For example, that he or she is not able to have children, although you discussed and you were lied to, and you thought that the person can have children. Force, if someone held the gun in front of your head in order to get married. Physically incapable. So it has to be documented from a doctor ideally, because how can you prove someone was physically incapable at the time when you got married? Now, child's custody, remember, this form is just to get a case number. This is more like an intention. It's not something the judge is going to rule because you filed it. No. So I would still fill out this form the way you think, but not to put too much weight into that. Legal custody of the children. So petitioner is you, respondent is the other side, and then you can pick joint or not joint. Legal for custody is who is making the decisions about major events such as medical, religious, and school. And then you put the intention. Physical custody, where are the children going to be residing most of the time? With you or with the other parent, or jointly, depending on what your schedule is going to be. Parenting time, child visitation and parenting time be granted to. So this is visitation, and this is, again, you can pick. The thing is, I don't check off any of these boxes. I only check off A and B most of the time. Child support, it's too soon to say how much. I leave it out. Spousal support, I always check off spousal support, payable. Petitioner, if I'm the one who will be asking for spousal support, or respondent, if I'm the one who thinks that the respondent will receive support. 8B, terminate the court's ability to award spousal support to respondent. So not going to happen if the marriage was more than 10 years. If the marriage was less than 10 years, I check that off. C, reserve for future determination the issue of spousal support payable to. So, for example, if the marriage was over 10 years, I usually check off both boxes until we settle or have a buyout version for spousal support. It really, really is not going to be a big deal breaker if you make a mistake here, because spousal support is going to be decided by the court, and the court will determine whether they want to reserve jurisdiction or not. And they will determine it based on the length of marriage. So over 10 years, the court always reserves jurisdiction over issue of spousal support. All right, separate property is the money and assets and debts you had before you got married. So usually we don't know. If you are in pure default, meaning if the other side is not going to respond, then you need to fill out this form. But in most cases, I just check off 9B to be determined. Check this off. Don't forget to put petitioner's name, respondent's name, and then 10B, determine rights of community, meaning joint from the date of marriage until the date of separation, and quasi, property outside of California, and then also to be determined. If it's pure default, again, this needs to be filled out. Other requests, attorney's fees and costs payable by the other side. Of course, if I'm filing and I know the other side has more money, I'll check that off or leave it out. Now, petitioner's name to be restored. And this is where I check off if I want to have my maiden name or another name to be restored to. Then I put the date of the client, signature, and if I'm representing the client, of course I sign here, but you wouldn't have it since you're watching this video. You're probably going to represent yourself. Okay. For more information, read FL 107. And notice you may redact, blackout social security numbers. I never would include any social security numbers because these are court records. So this applies for the people who filled out FL 160 who are going for pure default. Okay. So scrolling down, San Francisco San Mateo has additional form called SFUFC form 11.17. You fill out the same way you filled out before. Case number will be assigned later. Then you read all of this and make sure to fill out these tabs, and then you sign. Basically, it says that you have to acknowledge that you need to arbitrate before going into trial. In San Francisco, San Mateo, and most counties have that, where you you will be sent to mediation with the court or with family lawyer who volunteers for the court in order to settle before doing anything else in court in terms of litigation. It doesn't apply for short cause hearings. So if you file for attorney's fees and child support, spousal support, anything, it's only, you're not going to be sent to mediation unless you ask for custody and visitation. So in cases that apply to trial, you always will be sent to mediation first. All right, so this is how to get a case number.